Hi, a wonderful welcome to those who are watching my video and to Miss Nadia. Today I will be doing a video presentation on a public international law topic, which is mainly about the monism and dualism theory. Alright, we have known that international law is a very important part for country and in the constitution, as like many people have rights to law and they have rights to justice. Let's say if their own country cannot give them justice, they may find remedy through international law. Now, international law and international agreements isn't always as it used to, as there is two systems that separates them. Alright, to start off, there will be a situation which I'm going to talk about, which is the climate change multilateral environmental agreement. Although there has been an unanimous acceptance of the multilateral environmental agreement between countries, however, there has been research that shows that there are variations among compliance in various different countries, like the contribution varies among countries, and that some countries have a more higher compliance and a more strict compliance, while other countries has a lower compliance to them. And there are a few types of multilateral environmental agreement, and I'll be talking about one of them today. But before I start off, let me talk about the concept and principle of what the monism and dualism theory is. What is the concept of monism and dualism? We'll start off with monism. Monism mainly talks about international and domestic law are part of the same system. It is the single system where that courts will recognize the international law immediately and when they are applied as provision directly as domestic laws. The dualism theory is that they consider international and domestic law to be entirely distinct in nature, where they are not one of the same system but they are separated, which only permits an indirect judicial application. That's the one of the points I put, which is lex posterior derogate legi prior. This meaning to be the where translate to the later law replaces the earlier one, which means that dualist state, like they can choose whether or not they want to apply the effects of the international law or the international agreement, or they maybe they can choose some parts of it, like, or they have to wait for it to be translated into a legislation to adopt it to domestic law. This is the dualist system. Is I'll be explaining the deeper part of monism and dualism. Moving on, I'll be talking about one of the strong advocate for the monism theory is Mr. Hans Kelsen. Um, Mr. Hans Kelsen mainly talks about his group norm theory, where in his beliefs that international law and domestic law, which is also known as municipal law, is but a manifestation single unit of law, and that there's nothing that separates it, and that countries should behave as they customarily have in international agreements and domestic agreements, where like international law in Mr. Hans Kelsen's belief is that it is more superior to domestic law, which is municipal law. That's because that international law is mostly derived from state practice. On the other hand, the domestic law gains its power from states' internal affairs. Once that is accepted that international law is a system of legal character, it becomes like impossible to deny that there are two systems, because that it's shown in Mr. Hans Kelsen's theory that it is but a single system for domestic and international law. As his theory that international law and monism doesn't have a halfway house is because that he believes that international law and domestic law are as a single and coherent system. Therefore, he believes in his own theory that international law is placed at the top of the pyramid. Next up, moving on, we'll be talking about the dualism theory, which is supported by Mr. Heinrich Trypel's theory on dualism. In Mr. Heinrich Trypel's theory on dualism is he treats the two systems, which is international law and domestic law, as entirely different, like it's two separate systems, and that international law and domestic law mainly differs in like social relationships that they govern. Like while state deals with individuals, international law are dealings between countries, between states in relations. Therefore, he argues that their judicial origins are different, and that the source of domestic law is the will of the states itself, whereas the source of international law is the will of many countries. Like many states, they sit around, they discuss the effects and what it can be do, and they only come out with an agreement. Whereas a domestic law is between yourselves in the country, where it's internal affairs mainly. Like that also exists in difference such as subjects, sources, and contents, like mainly culture. While some countries, their international agreements or laws that they come up with may more suit to their own country's culture, it may not necessarily be suit to another country's culture. Therefore, in Mr. Heinrich Trypel's theory, he accepted that the basic will of states is the premise of legitimacy of international law, where he relied that international law has to be translated through before it can apply in domestic law. Like it has to be go through the constitution, and like it has to be translated before it can be adopted by the state and drafted and come up with, like, to mainly make it more suitable to the laws of the domestic laws of the country. All right, next up, I'll be talking about a few cases, which is showing you how does the dualism system and the monism system works. In the case of Trantex and Central Bank of Nigeria, this is to show whether or not an international agreement can automatically become a part of the domestic law. In this case, the Bank of Nigeria and Central Bank of Nigeria and Trantex, they have made an international agreement, and then like the appellants, they argued that it should automatically be adopted into the domestic law of Nigeria, whereas Nigeria argued that they have not made a legislation, they have not translated it yet for it to be adopted into domestic law. Therefore, they say that there is no there is no effects that can be bring from it yet. Next up, the court followed the dualism approach, which favors the Central Bank of Nigeria, and ruled that international treaties do not automatically be incorporated. It needs to be incorporated by a specific legislation. Mainly, it has to be drafted, and if possible, it has to be applied before to a case law, and then it can be applied domestically. So the main point of this case is that it highlights that dualism does not automatically incorporate into international law into domestic law. Next up is also a case showing how dualism works. It's the Yong Wei Kong and public prosecutor case. International law would not form a part of domestic law unless it is expressly adopted by domestic law of the state. In here, the appellant, he was caught for smuggling drugs, and that he wanted to appeal that the sentence of caning is torture and an infringement of a human's right, and that the Singapore court, they were part of a convention, and therefore he should apply the international convention to his appeal to prevent him from receiving the caning punishment. However, the Singapore courts, they argued that customary international law would not be part of domestic law unless it has been applied before or declared. In the event of conflict between international and domestic law will prevail. This shows that dualism is more favorable towards domestic law unless the international law has already been adopted by domestic law of the state expressly. However, in the events of conflict still, dualism shows that domestic law will prevail, contrary to monism, where if there's a conflict between international law and domestic law, international law will prevail as they believe it. The two of them are the same sides of the coins. Moving on, it is the European Council and others and Czech Republic. This is the case of talking about the Aarhus Convention of an environmental effect also, which is similar to the situation that we are talking about. Like EU members, they are free to agree on what provisions are to have in the internal order with non-members countries. Like they if are allowed to, although we know that the European Union, they practice mainly monism. However, we have seen like a little bit of mixed approach, as they aren't entirely monistic, as they sometimes they would pick out the parts of the provisions to their adopt into their internal order legal order with non-members countries. Like due to the monist approach, the provisions of the conventions thus will produce effect within the legal order of the European Union. This is showing that they are holding a monistic approach and that international agreements are more superior to all acts of secondary law. Now we will be looking at our situation. Why the situation happens of unable to harmonize it. Being one of the big agreements of climate change would be the Paris Agreement, where we showed that it is facing a lot of difficulties in ensuring compliance from countries, as mainly parties. We can't just look at monism and dualist system. The challenges are also like we have to look at various factors, which one can be in monism per se. The various factors to take account, like although it's automatically shown that international agreements are adopted into domestic law, however, once it's automatically adopted into domestic law, there might be conflicts between international law and domestic law, as sometimes the countries haven't made provisions on or judicial reviews on how the international agreement should be held if someone were to break the law. This is one of the part, as they automatically adopt it, but the country is not ready to handle it. Like they had not made provisions or rules or punishments that can be taken into account if someone decides to break the international agreement, often leading to cases left around there unable to continue, and public might not understand about it. Next up is the dualism. Dualism, the challenges mainly faced are time. Like there's a long time and delay when it can be implemented into domestic law, causing countries unable to make their contributions or compliance to the agreements, such as the Paris Agreement. Like countries, they have their own problems, and mostly they are more concerned about their country's internal affairs, and they are taking time to debate, legislate, and often facing delay, or it could be taken up to years for an international agreement to implement. As without a legislation to implement the agreement, the international agreement, it might not be able to show its full effects. It might not be able to show what it was created to do for. So in my own opinion, I have made a few recommendations that can be made to harmonize monism and dualism. Like first one being ensure clarity in translating international agreements into domestic legislation. This is towards the dualism. Like they have to talk about how what is the purpose of the international agreement, and public has to be educated when implementing new agreements. Also, in my own opinion, both systems, they could try to largely be beneficial by allowing more important agreements to ultimately be a part of domestic law, which is known as the jus cogens. For jus cogens is like self-executing treaties where human rights, all that, they are ultimately part of domestic law, and that the public must know what they are doing, what the government are doing, so that there's no confusion, and bipartisanship can be an important thing to reduce oppositions. So for my conclusion is mainly this is due to inconsistency and a lack of clear stance. Like countries does not want to show whether they are entirely monistic or they are dualist entirely. I believe that countries should take a stand and announce like whether they are following fully monism or fully dualism. As what from what I see, they are like using whatever is beneficial to them in dualism and monism, which this shows that mainly they're adopting a hybrid system where like they are not entirely monistic or dualistic. So they should probably announce their stand and to allow treaties to be implemented sooner, and this can show that the countries want to adopt a monistic approach or dualistic approach to prevent confusion and inconsistency. That's all for my video presentation. I hope you all learned something about it. Thank you. And this is my bibliography of reference cases which I use for my video. Thank you.